Hello, my name is Dana Adler, and today I've been given the opportunity by Dr. Angela Nichols to talk about international human rights law. And I am going to introduce myself first. My name is Dana Post Adler. I'm a PhD candidate in comparative studies at Florida Atlantic University. I have a Master of Arts in Human Rights Studies from Columbia, a Master of Business Administration in Marketing and Operations from New York University, a Bachelor of Arts in English from Cornell University. I'm a businesswoman, a Jewish communal leader, an activist and philanthropist, a wife, and a mother of 3. And I'm a dog mom. So today's discussion. Dr. Nichols has asked me to talk about international human rights law. We're going to do a little background and history of human rights law. We're going to talk about the UN Charter, the Universal Declaration of Human Rights, civil and political rights versus social, cultural, and economic rights, other covenants, and issues, remedies, and problems of enforcement. So let's go. Background of history of international human rights law. So, first question. What's the key role of government? The key role of government is to keep us safe, whether we're a citizen or a child or someone who's poor or someone who's rich. It's to keep us safe. So then what are human rights? Human rights are rights that we all have simply because we are human. And the laws are important because, quite frankly, otherwise there would be chaos. So when did laws begin? We know from back in Babylon, the Code of King Hammurabi from 1760 BCE, before the Common Era, wrote a series of laws that he used to govern. And then we can move to the Romans with the idea of natural law and the rights of citizens. And they were, over 1,000 years later. Now, interestingly, they talked about the rights of citizens, but the Roman Empire was vast, and there were many people within the Roman Empire. But only really citizens had rights. So who didn't have rights? Well, women were not citizens. Slaves were not citizens. Children were not citizens. And of course, foreigners were not citizens. So they didn't have the same rights as the Roman citizens. Fast forward to the Magna Carta in 1215, when you have King John, who made a deal with the barons. And it was really the first time where the king did not have absolute power. Then there was France and the Rights of Man in 1789, the French Revolution. And the rights of man were essentially universal individual freedoms combined with the social contract. So what's a social contract? The social contract was the idea, whether it's something that we buy into knowingly or unknowingly, where we give up some of our freedoms as individuals to the government. Why do we do that? So that the government can keep us safe. So if I have a dispute with my neighbor, I am not expected to pull out a gun and shoot him. I'm supposed to call the police. The police are part of our government. They are the ones who would arrest my neighbor. There would be a trial, etc. Then the United States and the Declaration of Independence in 1776 and the Bill of Rights in 1791. I'm sure you've all read those. I would ask you to read them again, particularly the preamble. And then you have the United Nations from 1945, after World War II, how the nations of the world came together to create a better world. And they created the Universal Declaration of Human Rights in 1948. So let's move forward. What is the UN Charter? The UN Charter is considered a treaty, and its purpose was essentially to prevent war, to maintain peace and security, to promote social progress and standards of life, to strengthen international law, and to promote the expansion of human rights. But who signed it? Originally, 50 nations signed it. Now there are 193. So what's the problem with that? Sounds like a good thing, right? Well, some people think that because it was written and created by the powers after World War II, which were primarily United States, China, Russia, and the European countries, that the rest of the world was sort of left out of what this really means. And we can ask, do the values in the UN Charter and really in the UN Declaration of Human Rights, Universal Declaration of Human Rights, do they apply globally as they did before? So let's move on to the Universal Declaration of Human Rights, 1948. What's the history of it? Who are the writers? Well, the writers were Eleanor Roosevelt, Rene Cassin from France, Pen Chung Chang from China, Charles Malik from Lebanon, and John Humphrey from Canada. Its reason for being, essentially, it was a roadmap to guarantee the rights of individuals everywhere. But importantly, and this is very, very important to know, that the Universal Declaration from 1948, it's not actual law, it's aspirational. Problems, issues with the Universal Declaration. Who was represented? Again, similar to the UN Charter, the African nations were not represented, the South American nations were not represented, many Asian nations were not represented, the Middle East was not represented except for Lebanon. And that's who signed it. But it did start to create international law. And again, why is law important? Because otherwise there would be chaos, and we didn't want the atrocities from World War II to occur again. And so what are these images? So you have your Declaration of Universal Declaration of Human Rights on the right. You have Eleanor Roosevelt holding it up next to that. And below, this is one of my favorite photos. This is my Uncle Mark with Eleanor Roosevelt. And I treasure that photo. She was a guest of honor at a charity function that he chaired many years ago. So I love to show that photo in my classes. So what's a covenant? A covenant is a promise, and it's another word for a treaty. So here we go. We've got the International Covenant of Civil and Political Rights, the ICCPR from 1966. So what are civil and political rights? Essentially, civil and political rights are negative rights. They are negative because the government is not supposed to interfere with the rights that those people have. So, civil rights, political rights. You have the right to life, not the right to life like the abortion people, but the right to life, the right to live your life. There should be no torture, no slavery, no compulsory labor, the right to liberty and security, no arbitrary arrest or detention, the right to a speedy trial, the right to privacy, the right of liberty to movement, the right to leave your country if you want to, or enter your country, the freedom of thought, conscience, and religion, the freedom of expression, the right to a name and a nationality. Now, it's important to note that the Universal Declaration, the ICCPR, and the next treaty, the ICE-SCR, they are combined. They are what is called the International Bill of Rights. So the International Covenant of Economic, Social, and Cultural Rights, the ICE-SCR from 1966, that covers another set of rights that are called positive rights. They're called positive rights because the government needs to provide these things in order for its people to thrive and to live. That's why they're important. So I wanted to mention also with the ICCPR, there are 173 parties to the convention, 6 more signatories without ratification. So you could see in the light green that you've got China that has signed but not ratified the ICCPR. Again, many issues with civil and political rights there. It's a communist country. Freedom of the press, freedom of speech, freedom to vote, etc. Maybe issues there. Also, you see in red, North Korea. They have tried to leave the treaty. And here, interestingly, the light green, the United States has signed but not ratified this treaty. You have 171 parties to the treaty. The U.S., as I said, did not ratify it. We didn't talk about reservations. So what are reservations? Reservations essentially are caveats. They say, yes, we'll sign this treaty. However, this particular portion we're not going to subscribe to. So that's allowable in international law. So what are civil and political, what are economic, social, and cultural rights? Well, examples, the right to work, the right to Social Security, the right to have a family, an adequate standard of living, including food, clothing, and housing, a right to health, a right to an education, and a right to a cultural life. How is this enforceable? Just like with the ICCPR, there is a mechanism, there is a committee that individuals can go to. But before they get to that committee, they have to exhaust all domestic remedies. So anything that is available in their country, if they have an issue or problem, then they can go. They have to exhaust all domestic remedies before they come to the committee. Problems with the ICCPR. So sometimes Sharia law, for example, could be a problem. You see that Saudi Arabia is not a signatory to this covenant. And many of the Arab countries, Muslim countries, have reservations when it comes to both of these covenants. Discrimination. Can't talk about international law without talking about discrimination because, interestingly, it is a common theme in all international treaties of non-discrimination. So the CEDAW, for example, is the Convention on the Elimination of All Forms of Discrimination Against Women and Girls. There's also the Convention on the Rights of Persons with Disabilities, etc., etc. But what is discrimination? It is the idea that individuals are unable to enjoy a human right because of unjustified distinction in the law, policy, or treatment. And so it is defined by international community, and if there are signatories with certain laws, then they can be brought up to international court. However, most discrimination women experience is not directly related to activities of states. It's related in the home, in the culture, at work, with private corporations. But there are other treaties and treaty bodies that address discrimination as well. Oh, and what does it cover? It covers gender equality, women equality in political life, coeducation, nationality, the right to work, the right to family planning. There's economic rights, bank loans, for example, and adequate health care, parental and marriage rights. It's important to mention that UN Resolutions 1325 and 1820 work in conjunction with the CEDAW. It's women's participation in peace and ending conflict, as well as an end to any kind of sexual violence. Moving on to statelessness, refugees and migrants. So international human rights law is constantly being tested. Some governments limit the influence of migrants and expel residents and deny fundamental human rights to people within their borders. So the question is that legal? UN member states try to develop frameworks in order to safeguard the rights of refugees and migrants. But what are the rights of refugees and migrants? Refugees are defined as those fleeing an armed conflict. The core principle of a refugee is non-refoulement. It's a French term, and it means that they cannot return to their country because there they would face threats to their freedom or their life. Migrants, on the other hand, leave their country because of economic reasons. But does the distinction between migrants and refugees make sense? And shouldn't international human rights law be sufficient for everyone? I'll just leave that question out there. So, statelessness. I'm going to read this portion to you from Hannah Arendt. It is possible to say that even slaves still belong to some sort of human community. Their labor was needed, used, and exploited, and this kept them within the pale of humanity. To be a slave was, after all, to have a distinctive character, a place in society, more than the abstract nakedness of being human and nothing but human. Not the loss of specific rights then, but the loss of a community willing and able to guarantee any rights whatsoever, has been the calamity which has befallen ever-increasing numbers of people. Man, it turns out, can lose all so-called rights of man without losing his essential quality as man, his human dignity. Only the loss of a polity itself expels him from humanity. And so here the world community tried to set up something. They created nation states. The problem is, if you don't belong to a nation state, you really don't have rights. And what's happened since 1948, when Hannah Arendt recognized this problem, is that there are now 65 million people who are stateless in the world. And again, the international community tries to remedy this. There's the Convention relating to the status of stateless persons, the Convention to the reduction of stateless persons, the Convention related to the status of refugees, the guiding principles on international displacement, the Model International Mobility Convention, etc., etc. Now let's talk about peoples and minorities and self-determination. So both the ICCPR and the ICESCR include the principle that all peoples have a right to self-determination. But who or what is a people? A people is an ethnic group that shares culture, language, religion, etc. Sometimes they even consider themselves a nation. But a people under the law is also a corporation. You can sue a corporation, and in the law, it is treated separately as a person. In other places, a river is considered a person under the law. So what's self-determination? Well, self-determination is the idea that one can determine one's fate, but that maybe isn't the same as a nation state. So how do these concepts relate to indigenous peoples within the UN Declaration on the Rights of Indigenous People? Well, indigenous people are not always able to secede the place where they live and create their own nation state. The UN Charter, Chapter 1 says that peoples have the right to self-determination, but what does that really mean? In the conflicts in the world, there are still many, the Kurds, etc. There are minorities who want their own nation state because they believe that that's the way that they should have self-determination. Rights in emergencies. Sometimes human rights do not apply. We have this draft articles on responsibility of states for internationally wrongful acts, drafted in 2001. When a state is in breach of their international obligation, and then you can have government officials who are brought to trial. You could have private individuals, non-state actors, ISIS, etc. You have failed states. So there's all kinds of international law that's been gray that needs to come into play when you're dealing with contemporary times. Then you have rights emergencies and the question of infinite detention. Well, we have the Patriot Act here in this country since 9/11, where many of our freedoms have essentially been put on hold. You have infinite detention in Guantanamo Bay, for example, because Patriot Act says that we're under threat of war, or we're under war, and the government can take more power. It's important to talk about the Geneva Conventions 1, 2, 3, 4, and additional protocols 1 and 2. Now, the Geneva Conventions were set up as rules of war. Wounded and sick soldiers, wounded, sick, and shipwrecked soldiers, prisoners of war. And Geneva Convention 4 is important to talk about because it talks about protecting civilians. This was not necessary, really, until World War II. And then how are civilians treated within an occupied territory? Of course, in Article 3, there is a common article that talks about humane treatment of everyone and no torturing. Protocol 1 talks about protection of victims of international armed conflict. Protocol 2 talks about non-international conflict. Okay. International institutions and the enforcement of international human rights law. How can international organizations persuade or compel states to comply with international human rights law? Well, and how do monitoring and complaint systems work? As I mentioned, individuals must exhaust all domestic remedies and then go to the committee through the UN. What role does the UN Security Council play? And what is the responsibility to protect? So states have responsibility to protect everyone living within their borders. But how can and should this be used? So the big question is, countries can use sanctions to make other countries comply. They can also use boots on the ground, and force is always something that we're all very hesitant to do. You also have regional organizations in human rights. So regional organizations can play an important role in developing, interpreting, and enforcing international human rights. Are regional organizations better suited than global ones to accommodate cultural and other differences? And are they more likely to elicit compliance? So you've got your European Convention on Human Rights, your African Charter on Human Rights and People's Rights, the American Convention on Human Rights, and the Council of Europe. You've got Margin of Appreciation. So there's some leeway into how the global community works, and with respect to certain areas of the globe, which may be more aligned with values, local values. I'd love for you guys to read these and talk about the differences and similarities in some of these regional organizations. So justice, state jurisdiction, and criminal responsibility. You have the International Criminal Court, the ICC, which the Rome Statute, international tribunals. Are they fair and effective? Well, people have been sentenced and put in prison, but do their remedies translate into reparations and effective remedies? Again, it's something I'd like you to contemplate and talk about later. And in conclusion, I'd like to thank Professor Yasmin Ergas, the Director of Human Rights Institute at Columbia, whose International Human Rights Law class from the fall of 2018 syllabus I used as an outline for this lecture. And I'd like very much to thank Professor Angela Nichols for the opportunity to videotape this lecture for you today. Thank you so much.